Welcome to today's program titled Workplace Political Expression, Best Practices for Balancing Employee Rights and Employer Responsibilities. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread, and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Dawn Soloway. Dawn, please go ahead.
Thanks so much, Kate. Thanks everyone for being here this afternoon. We are pleased to present this program on workplace political expression, which is a very hot topic these days. We're handling lots of counseling questions in this space from our clients. This is an era that is, of course, very polarized, and we are in an election year, heading closer and closer to the election. And at a time where we encourage employees to bring their whole self to work, we are also finding that employees bring a lot of political opinions that they express in and out of the workplace, and that are sometimes very divergent on hot button issues. And so that's what we're going to cover today. Very pleased to be here today with two of my partners. Marjorie Culver is here. She's a partner in New York, and she is a member of our International Employment Department. And so she'll be providing a global perspective. I know many of our clients and friends on the call have global operations, and so Marjorie will be speaking to that. And then Sam Schwartz-Fenwick, who's a partner in our Chicago office and is a co-lead with me on the Cultural Flashpoints Task Force. Just take a moment to explain what we mean by cultural flashpoints. This is a task force that Seyfarth developed in recognition of the fact that workplaces are not immune from polarization in our society, and that there are a lot of cultural conflicts that are on the rise. And our group helps to help employers to have effective strategies to lower the temperature, or if that's not possible, to defend against litigation. And so Sam and I are regularly consulting with clients about all sorts of cultural flashpoints, including those that are about political expression. Next slide, please, Kate. So today we're going to talk first about some state law considerations when it comes to workplace political expression. And then Sam is going to cover the NLRB's approach to political expression. I will speak briefly about Title VII considerations in this space, and then Marjorie will take us beyond the United States to provide a little more of a global perspective. Next slide. So we wanted to start with some state law considerations, but kind of backing up even from there on the next slide, start from the premise that the First Amendment applies to government action. And in general, there's no constitutional free speech rights in a private workplace. That's sometimes a misperception among employees. And there is no explicit federal law protection against political discrimination. Although part of why we're having this webinar is that it's important for employers to tread carefully because of potential overlap with other forms of discrimination and other legal restrictions. I will just note that DC does prohibit discrimination based on political affiliation. And there are some states that provide some political speech protections, and the scope of those laws varies widely. So whenever you're dealing with a question of political expression in the workforce, one of the first questions you want to find out is what jurisdiction is this employee in, so that you can properly identify whether there's a state law that comes into play. So one category of state laws has to do with interfering with or restricting speech or conduct in the workplace regarding electoral activities. So over 40 states have laws to this effect, and those laws will generally prevent an employer from coercing or trying to coerce an employee's voting activity or political activity. So some of those activities that might be covered are influencing or trying to influence, either joining a political party or voting for a particular candidate on a particular issue, requiring any political contributions to any specific party or candidate, or including political mottos or similar messages on pay envelopes. We're going to talk just today at a very high level, so the specifics of those laws will vary state by state. Next slide, please. Another category of laws are what are called captive audience laws. These have to do with captive audience meetings, which are mandatory group meetings that are held by the employer during working hours to communicate with or educate employees. These were historically allowed and not particularly controversial. But in 2022, the NLRB General Counsel issued a memo claiming that these meetings violate the NLRA. And so we're seeing more and more states now passing laws that prohibit captive audience meetings on certain topics like political or religious matters, and make sure that there is no retaliation for opting out of such meetings. So this is kind of another category of state laws, and you'll see on the slide that there are 7 states that have this kind of law in effect, and 2 more have passed them, but they're not yet in effect. Here in Massachusetts, where I sit in Boston, there is an employee free speech captive audience bill that's pending, but it's not yet on the brink of becoming law. Next slide, please. So like I said, these laws vary widely by state, but we wanted to highlight 2 in particular that go a little further than the laws I've previously been discussing. California, for example, has broad-ranging protections for political activity and for lawful off-duty conduct. And they define political activity very broadly. So that has been held by the courts to include advocating for gay rights, publicly criticizing a public official, wearing symbolic armbands, and associating with others for the advancement of beliefs to be political activity. Lawful off-duty conduct is also defined very broadly and very vaguely. And that includes activity that is already an existing right under either the state or federal constitution, such as activity protected by privacy or free speech rights. Connecticut is another state that is kind of an outlier in this space. It extends First Amendment protections to speech by employees of private companies, and it bars most private employers from disciplining or terminating an employee for engaging in any type of political speech that would be protected by either the Connecticut or the US Constitution. And there is an important carve-out that the law does not protect activities that substantially or materially interfere with the employee's bona fide job performance or the working relationship between the employee and the employer. Next slide, please. So the big picture message from today is to know your state laws. So if you get a question about political expression by an employee, you want to make sure you understand where that employee lives and works. because this is an area where there is very much a moving target. New laws are being proposed and passed all the time, as well as legal challenges to those laws. And so that's why we included the state laws first, because that's kind of one of the first questions is where you are geographically. And then in the next slide, Sam is going to talk about the National Labor Relations Act.
Thanks, Don. I love that slide, know thy state laws, and I really think that one of our hopes of doing this webinar is to help people issue spot so that when they see something like this, they are thinking in their heads about the state, federal, and with Marjorie, the international legal components, so that when they are then talking to the decision makers at your company, you can at least provide the legal context, because there's a ton of other context to how to respond to political speech at work. There's a business component, there's a workplace satisfaction component, there's a lot of things to consider, but at least understanding the guardrails of what the law allows and the legal risk associated with different choices, that's really a value add that you can provide by being able to issue spot. And of course, reaching out to Seyfarth when it makes sense. All right, if you could flip to the next slide. So Don mentioned the National Labor Relations Act, which is often referred to as the NLRA, and was talking about the captive audience views of the current general counsel. And we're going to get into her beliefs in a little while. But for right now, I think it's important that every employer recognizes that whether or not you have a union, you are subject to the National Labor Relations Act. And one component of the act that's relevant to our discussion today is that under the National Labor Relations Act, employees have the right to engage in protected, concerted activity. So historically, this was really a foundational principle of the NLRA. Let's say you have workers who feel it's too cold in their office. They, walk in together shivering to their manager and say, like, we need you to turn the heat up. Okay, that is, kind of the epitome of protected, concerted activity. It's concerted, meaning on behalf of multiple employees, and it's also peaceful and lawful. Now, over time, what protected and concerted means has been up to a lot of debate. But at base, it wouldn't include someone saying, hey, I really hate the location of my locker. It's out of the way. Why are you doing this to me? Woe is me. Okay, that's someone acting on their own behalf for their own personal needs. But beyond that, there's a lot of uncertainty, and especially with the current administration, they've really been trying to take notions of protected and to mean far broader things than have traditionally been understood. For instance, the current leadership of the General Counsel, which litigates on behalf of the board, they've taken the position that civility policies, things like being respectful at work, are generally unlawful to the extent they don't make exceptions for people perhaps swearing in advocating for protected, concerted activity. Their view is sometimes to get your message across, you need to get fired up, and swearing is part of that. Historically, someone swearing at work was obviously something where discipline was appropriate, and no one thought about the NLRA. So I just wanted to give that background as, where things are shifting as we dig in more. If you could go to the next slide, Kate. Thanks. So under political speech, again, whether or not it's protected by the NLRA is going to hinge. Sorry about that. I was getting so excited. I was talking with my hands and I knocked my headset off. So whether or not it's covered by the NLRA is going to hinge on whether you're talking about working conditions. So whether the activity in question relates to work. So traditionally, talking about something like minimum wages, overtime, temperature in the building, as we previously discussed, vacation days, activity like that is going to be inherently protected. Historically, things like criticizing who your employers have business dealings with, that's unrelated to your terms and conditions of employment. So historically, that has not been viewed as being covered by the NLRA, and it was grounds for termination lawfully if you were bad mouthing who your employer was doing business with. We can see, though, in the past few weeks, I'm sure everyone has seen the various work stoppages across the country protesting corporate relationships with Israel. And in light of the Hamas-Israel war, and there have been a number of NLRB charges alleging that terminations for these work stoppages and sit-ins violated the National Labor Relations Act under the theory that these were protected concerted activity. You know, that part of in the current day-to-day world that we're operating under, who your employer does business with, it really needs to be viewed part and parcel of terms and conditions of employment. And I think that to get a little background on that, it's important to think about, you know, recruiting and retention efforts. And we know that with the younger generations of workers, when they're coming to work, they're not viewing their job as a 9-to-5 job. They're viewing it really as an inherent part of their identity. There's a lot of branding where employees are wearing clothes outside of work with their employee's emblem on it. And it's really become a retention strategy for people to feel proud of their employers beyond just a paycheck. So I think in many ways, what we're seeing with these recent charges, which by the way, none of them have moved past the charge stage yet. So I don't know how they're going to come out, but the fact that these charges have even been filed, I think really reflects a fundamental shift in how people are thinking about the workplace. But so what we're going to drill into next is what is really viewed as political speech covered by the NLRA and what isn't. So let's go to the next slide. So there's a black and a white and a gray here. So advocating for a political candidate, advocating for a political party, or even, you know, the MAGA movement, those are not protected by the NLRA. So you can have a policy that says, you know, at work, we don't want you, it's impermissible to have a sticker or, you know, I guess for MAGA, a flag or a hat reflecting a political movement or a political candidate. It gets more challenging though with the next two bullet points. And there I would say, while historically advocating for, you know, using slogans for a campaign, for instance, or challenging your employer's business dealings, those would not be protected by the NLRA. Right now, it's more uncertain. The third bullet, I would say it kind of depends on what the idea is. It's, you know, if you're talking about, you know, you want, you know, vote for Biden because he supports tort reform. Okay, unless you work at a law firm, that's going to have nothing to do with the terms and conditions of your employment. However, if you say something like, you know, the social justice issue of the day, you know, stop business dealings with Israel, you know, I'm proudly pro-life. a whole plethora, Black Lives Matter, right? There's a whole host of ideas that are closely linked with political candidates, but they're not naming them. And for some of them, I would say Black Lives Matters, for instance, the position of the NLRB, let's go to the next slide and then we can come back. The NLRB at least has said that wearing paraphernalia associated with Black Lives Matter in the context of racial animosity in the workplace is protected concerted activity under the act. Here, Home Depot had terminated an employee for wearing it's not a sticker, but like a little badge, like a Black Lives Matter badge on their Home Depot apron, and they were terminated for doing that. And the National Labor Relations Board said that's impermissible. You're taking action against someone who's speaking out about racism at work, even though the Black Lives Matter movement is far broader than what happens at one specific workplace. Now, interesting to note, this Home Depot appealed this decision, and while the appeal was pending, the parties have tentatively settled. And if that settlement is approved, Home Depot is going to have to post a notice throughout its workplace. And whether or not they'll have to bring back this employee is uncertain, but that might be part of the remedy as well. But here, the board still tied the protected concerted activity to actual conduct at work. What the general counsel we were talking about before, her vision is much broader. I think if there's a second Biden term, we're going to see a case that has to directly deal with her view. In her view, social issues are inherently protected concerted activity. This view that there's a divide between the public square and the private employer when it comes to social issues is a fiction. And in her view, kind of by any means necessary, you need to be able to advocate for social change to deal with systemic societal issues. So if that view trumped, then it would be very hard to maintain a speech policy at work that prevented employees from talking about any societal social issue. Again, though, that's not the law right now. So I would say this is a gray area. And so you need to think about, where do social justice issues land between, this permissible BLM sticker and something that might be, the tort reform example, and how far in the gray are you willing to have a policy, and what legal risk are you willing to stomach, understanding that we could have a new president elected in November, who clearly would appoint a general counsel who does not espouse the view of the current general counsel on this issue. The same goes with, what do you do for employees who are engaged in political speech that is disruptive to the bottom line? For instance, a sit-in in the workplace protesting your business dealings, holding up signs saying, the products of my employer kill. Things like that historically have been viewed as, clearly actionable by an employer to be able to take action. I think right now it depends on whether you want to wait and see how these recent slew of cases before the National Labor Relations Board resolve before taking action, realizing that if you do discipline or terminate someone for this conflict or conduct, you might end up on the front page of the newspaper. Versus feeling like, this is what you need to do in order to keep your legitimacy and control over a workplace and prevent it from just spiraling out of control with recriminations on both sides. There's not an easy answer. And so again, you want to just present the current lay of the land to the various stakeholders and make sure to be checking in with council because the lay of the land is shifting under our feet day to day. So another complexity on the next slide deals with off-duty conduct. Now, we previously had a webinar on off-duty conduct that was fabulous. Everyone should listen to it. It's recorded. And as a snapshot of what we talked about there is that currently the federal agencies do not agree over what steps employers can take with respect to off-duty conduct. So in the view of the NLRB, disciplining an employee for off-duty conduct, including social media posts, can violate the act because you're impeding their rights to engage in protected concerted activity. At the same time, the guidance from the EEOC is if an employer learns about off-duty conduct by an employee and is told that it's creating a hostile work environment, it makes folks feel not safe to be at the workplace because of that, or it's just hostile towards who they are, that the failure to take action by the employer can also give rise to a Title VII liability. So squarely opposite views. The agencies luckily recognize that they're putting in employers in an impossible position right now. They were going to put their heads together and come up with a policy that squared it. It now seems though like it's going to first have to go to public hearings. So given the snail's pace at which everything in Washington moves, who knows if or when this will happen. So again, if you're presented with off-duty conduct, you have another risk calculation of what do you want to do in this situation. And so it's a really good point, again, a decision point to present the view of the EEOC, to present the view of the NLRA or under the NLRA, and then to reach out to counsel to make sure you have the most up-to-date view of the law before talking to your decision makers about what conduct to take in a specific space. And then this last point that I want to make before turning it back to Dawn is what types of policies should employers have? You know, I think that we all know that the best way to ensure uniformity and to really state our position in a defensible way is to have a policy. And a risk with a policy is under the current administration of the NLRB, they're very suspect of employer policies because they're viewed as chilling of organizing activity. So under the current law, there's the stair cycle decision that was issued a few years ago by the NLRB, and anyone who practices in the labor law realm knows that it's really called into question virtually every employer policy. Because under stair cycle, a policy violates the National Labor Relations Act if it's likely to make a pro-union employee less likely to engage in protected concerted activity. So it's not your typical employee, it's your typical pro-union employee is the standard. And, you know, the wind could blow the wrong way and it could chill a pro-union employee. So it's really hard to know what policy can withstand scrutiny before the board. We have some language that hopefully will withstand scrutiny. You know, you can put in disclaimer language and things like that. But overall, the board seems very reluctant to allow policies to be upheld under the current standard. And so it's something that employers need to think about and, you know, kind of decide their stomach and risk tolerance moving forward. Okay, so with that, I want to flip it back to Dawn. So we go to the next slide.
Thanks, Sam. So we've talked about state law issues, we've talked about the NLRA, and another framework that it's important to think about political expression within is Title VII, which is the federal law that prohibits discrimination, harassment, and retaliation. Next slide, please, Kate. So we've talked a little bit about off-duty conduct versus on-duty conduct. And at the same time, we know that the lines between those two things are getting increasingly blurry, right? Because people are working in hybrid arrangements. They may be working remotely. People have their phones with them at work and at home. They may be Facebook friends with their coworkers. And so, those lines that used to be fairly well drawn are increasingly gray. And so with respect to political expression, one of the threshold questions is, does this political expression impact the workplace at all? Right? So imagine that somebody, puts on their Facebook page, MAGA 2024 or build the wall or riding with Biden. That is probably not by itself really going to have any particular impact on the workforce, and nor can you as employers really get into monitoring every employee's every social media post, right? That wouldn't be practical or desirable. And so the question is, does that political expression impact the workplace in some way? So one way it might affect the workplace is by having some effect on coworkers or by giving rise to complaints. I know we handle a lot of questions from clients where, employee has brought in a screenshot of something that was posted on social media and says, this is what, Fred down the hall was posting on Twitter, and I don't feel safe working with him anymore. And so at that point, this isn't some esoteric statement that's made out in the world. This is something that has actually come to your HR department or to your in-house legal department and is now impacting your workplace. Does it have effect on job duties? So this is going to depend a lot on the role of the particular employee who's making the political expression. So if it's a warehouse stalker, that's going to be a lot different from a corporate leader or from, say, a recruiter who is, out there on social media trying to publicize the company and bring people into the hiring pipeline. Does the political expression impact the workplace? And I think, we have seen this really accelerate over the last, year or so in terms of how quickly somebody can make a comment on social media and then it is picked up and sort of metastasizes on the internet. And in a lot of cases, there's sort of a campaign to try to identify who is that employee who's made that post or who's done something out in public. And you swipe right to see their LinkedIn page, and all of a sudden, the company is getting tagged in terms of, why does this company continue to employ so-and-so who said this outrageous thing? And relatedly, does this political expression have some sort of effect on customers, investors, applicants, or some kind of other effect that is kind of directly bringing the expression into the workplace? Next slide. The other question is whether the political expression implicates a protected classification under Title VII or related, state analogs. So, political expressions, something like, Biden or Trump 2024 is not going to really implicate any protected classification. But a lot of political expression does, right? So it may have some sort of reference to race or religion or gender, national origin, marital status, gender identity. And to the extent it does, and it's impacting the workplace, now you have sort of a live Title VII question. Next slide, please. Relatedly, does the political expression violate a company policy? So Sam talked about respect for others policies or political expression policies, which I would sort of put in a separate category for something that you want to take a look at in today's environment to make sure that your policy is up to date and compliant. But at the sort of basic level, does the political expression that you're looking at violate your anti-discrimination policy, your anti-harassment policy, your diversity and inclusion or EEO policies? Because that is sort of a framework that you already have in place as to what kinds of speech or conduct are acceptable or not acceptable in your particular workplace. Next slide. One thing that we often counsel employers who are calling us with these sorts of flashpoints and political expression questions is to make sure you keep well in mind the duty to investigate under Title VII. Because if a company is on notice of a potential issue of discrimination or harassment or retaliation, there's a duty, a legal duty to investigate, and that needs to be a prompt and thorough investigation. And if a violation of your policy is found, then the employer has to take prompt corrective action. So, if a complaint arises out of political expression, and it does impact a protected classification and you get a complaint about it, then you have an active duty to investigate. And I think, one of the things that we are often counseling is particularly with these in this polarized time where there's tensions are very high, and employers are reacting to these flashpoints kind of in real time, is to sort of take a deep breath and first of all make sure that we actually know what the facts are. So if you've got just a screenshot from an employee, you want to look a little further as to how did they get this screenshot. Make sure that it's actually accurate, not making assumptions, not taking the internet's word for it. And making sure that you are, really dealing with the correct facts, getting a complete account from the complainant, and providing due process for the accused. And I think particularly in this era of AI and deep fakes, and it's sometimes really challenging to know what is actually true. And you want to make sure that you are providing adequate due process for the person who's accused, so that they can provide some explanation or any facts that you may be missing. And then, of course, the investigation should be reasonably thorough, and there should never be any tolerance for retaliation for having brought forward a complaint. Next slide, please. So we also talk to clients a lot. Seyfarth has kind of a motto of around voice of the client, which is whenever we're doing counseling to sort of start from understanding the client's perspective and what their business objectives are, what their legal objectives are. And I think particularly when we're dealing with flashpoints and political expression, that's especially important, because we will sometimes counsel a very similar fact pattern to multiple different employers, and they will take very different actions. Sometimes they really want to terminate or discipline. Sometimes they really don't want to and are asking, do I have to? And everywhere and anywhere in between. So, questions around what is your company culture, the temperature of the political expression questions is going to depend a lot on what your workplace is like. Some of our clients are very politically active nonprofits, right? And they'll say, there's no possible way that we could try to restrict political expression. That's our whole organization's mission. Other clients where they're really not involved in politics and really are just looking to kind of keep politics to a minimum and stay focused on, producing the product. And so that's going to vary a lot from employer to employer. And you want to think about, practical considerations as to how can you stay reasonably consistent, what boundaries are actually going to be enforceable in practical terms, how much bandwidth does your, HR group or in-house L&E group have to handle these questions. So before we move on, I do want to give you the CLE code. So if we could have that slide, Kate, thank you. So the CLE code for today's program is SS, as in Seyfarth Shaw, 7352, SS 7352. And with that, I will turn it over to Marjorie, who will provide a global perspective.
Dawn, just one sec before we turn it over to Marjorie. Sorry, just one thing to consider in terms of whether to, that clients have to consider when deciding what, if any, consequences to impose in these situations, is that even if you're able to take, terminate someone or discipline someone, you do want to think about what is the response of other workers going to be, and are you going to have protected concerted activity in support of whatever led to the initial discipline. So a real risk to think about, because it does have legal implications, is by issuing discipline, are you making a martyr out of someone, and thus really amplifying their message and creating further legal headaches. So it's just something to consider that we've seen metastasize at a lot of our clients. All right, and with that, I'm sorry, it's off to you, Marjorie.
Sorry, I'm getting in there. Sam, that was very convenient timing because I knocked my computer over. So thank you
Oh, no.
for
I feel better
covering
about my
the
headset issue
time
then.
that I had that little malfunction. So I want to start with this is going to be very high level. I won't be able to cover all the countries here, and I'm not going to get that specific. But I want to say the good news is some of these same principles that you would apply in the US actually work in addressing this topic, work really well outside the US also. So the policies you have in place, the education and training you have in place about discrimination, harassment, respect in the workplace, all of those work well outside the US. Where we have to keep in mind outside the US are some nuances, and also this philosophy outside the US that employees have a lot more protection at work than here in the US, especially when it comes to termination, but in a lot of other areas as well. So I'm going to go through a little bit about the sources of those protections and how they're viewed in principle, and then try to address some of the other issues we have, such as discrimination and privacy, and how they intersect. So let's go ahead to the next slide. Okay, great. So in many countries, the source is their constitution. And unlike in the US, it doesn't just apply to state actors. So the First Amendment rights, it doesn't apply just to state actors. It's broad and it finds itself in the workplace. So that's a very important distinction when someone talks about their freedom of expression. You don't have to be the government to trip over that. The other thing to keep in mind is the scope of protection. It can be very specific. So political expression, freedom of association, freedom of religion, but also freedom to join a trade union. That is in a lot of constitutions around the globe. So it is broader than just a workplace type law. It is a mandate in the Constitution that they have the freedom to join trade unions, which has implications for the workplace. Additionally, the right to privacy is in some constitutions. The right to a private life is in some, it's in the EU Charter of Human Rights. So all of these make its way into the workplace. Employers just don't have the same leeway that they would in the US. But regardless, there are interests to be balanced with business interests. You heard Don talk about social media. We all have gone through outside the US the issue of rolling out a social media policy and getting it passed through a works council in Europe, or getting it through the employees without complaint, because they feel like what I do outside of work is my business. I have the right to privacy. So all of that will sound very familiar when we're talking about political speech. So I'm going to stick with this slide a little bit, and I'm going to say balancing business interests. Again, is it disruptive in the workplace? That's one thing to balance. Then the other is balancing against other employees' rights, the right to feel safe, the right to not be discriminated against, the right to the protection against bullying. And I like to bring that one up because it doesn't require any sort of discriminatory intent. It can come up in this way. My complaint about bullying, my manager keeps telling me I'm stupid because I'm going to vote for so-and-so. I mean, there's no discrimination there. It's against the respect at work policy. but it doesn't really have a discrimination angle as we would know it in the US. Outside the US, it can be considered bullying, which actually does have legal consequences for an employer. So I think that should be kept in mind when you're talking about political expression. It doesn't have to be discriminatory to have a negative impact on employees. That is actionable by the employee. So let's go to the next slide. So moving on to talk about discrimination in a little more detail. As I mentioned, the scope can be very broad. Association, belief, affiliation. In some countries, you can't discriminate against someone because of their last name, because from medieval times, some last names found their way from very non-flattering terms, and apparently people are made fun of. So you have broad categories in every workplace. And the issue is that some of this political speech really intersects with some of these other protections. I'll give you an example. Some unions in Europe, they're affiliated with a religion. You have a Catholic workers union. Some unions are affiliated with a political party. You have communist unions. Same with political parties in some countries, Christian Democrat Party. So these lines intersect. So when you're talking about restricting political expression, and you're talking about how that impacts someone at work, when it's right next to them creating a hostile environment, you're going to find a lot of intersection with a lot of potentially discrimination issues, especially on the union front. I mean, there are, if there are some employers that have a full-time union person on site, they have an office, they have a position in the company that's there just because they're the union representative. It's a very large company. So you're going to find activity that's done on work hours. They're actually paid to do that. And some of it might go over the line that you would normally think, well, that doesn't seem really like union business. But when it comes to agendas, and the unions are very active at the national level on political agendas, you're going to find it tripping over the line, and taking action might get you in some trouble there, especially because of the broad constitutional protections. So I wanted to mention this EU Human Rights Charter. This is a protection against discrimination. This is what freedom of expression, freedom of thought, freedom of association. That's where all the sort of Bill of Rights type of things we would think about are included. And I mentioned it doesn't really require state action. You have employers who have been sued at the European Court of Human Rights for violation of some of the human rights charters, freedom of expression. So it's also something to keep in mind. Now, all of those human rights the charter, the Bill of Rights, they've all made their way into labor law in most countries. So you're going to find it in the labor law anyway. You're navigating it already. You're creating policies for respect for work, non-discrimination. You're trying to keep the workplace as neutral as possible. And I will say that culturally, outside the US, the workplace is more neutral. There is this idea of the sphere of a private life and a work life, and it is more generally respected outside the US. We really rarely get these questions from our clients who have operations in Asia, for example. We might get them in Europe. We don't get them very much in Latin America. We do get them in the US. So it really you have to keep in mind the cultural considerations. And a lot of your policies that already exist, your anti-discrimination policies, are going to be effective to help take the temperature down. I'll give you an example that, when the Ukraine war broke out, there were employees who were sending mass emails to generate support or express their view on their support for Ukraine. And some of these emails attached some very graphic pictures of what they thought were human rights abuses, atrocities. So these are actually, so that type of activity, just because outside the US, you're more broadly protected and you have maybe more right to express your views, you still have the general principles that an employer can prohibit the use of its tools except for business conduct and business, the company business. So you can't use the company email to send emails to everybody about non-work subjects. Also, the content being very inflammatory, triggering for some employees, that also steps over the line of your proper email use policy. So there are other tools to help bring the temperature down and make the work environment a lot less inflamed, I guess is the word I would use there. So next slide, please. I want to talk about this concept, private versus work spheres. You know, we do talk about off-duty conduct. It's an issue here in the US as well. Outside the US, and I'm gonna highlight Europe here because their view of privacy rights is probably the most expansive that we have globally. They view things like looking at social media posts as monitoring, right? Even though it's publicly available, if you are looking at your employees' social media posts, they see it as monitoring employees, and that's an invasion of their private life. It's not their work life, it's their private life. But at the same time, if it's, say, LinkedIn and their posting is related and right there next to who their employer is, and as mentioned before, depending on the level they are in the company, there may be a business interest for the company to monitor and maybe to approve certain posts that might be controversial. So there's a greater interest there when what you're doing outside your private life connects more tightly to your work life as well. Same thing as if the employees you work with are seeing your posts regularly, especially your subordinates. So this will always seem very familiar to you when you talk about off-duty conduct in the US, but outside the US, it comes from a perspective of privacy and a support for someone's privacy and private life. You know, especially in the workplace, there is this recognition of some aspect of private life in the workplace, and you can have some occasional right to use email for private use, and the employer can't see it, they can't look at it if it's marked personal and private. So, you know, balancing those two interests, the business interests of the employer, the private life of the individual, you know, it's delicate, but it still can be done. And I think some of the same principles that we use in the US do apply here. Some of the same watch outs that we've talked about earlier in this session will guide you similarly. And again, I think you look at how tightly is it connected to the business? What kind of impact is it going to have on the business? What is the impact on the health and safety of workers, especially when it comes to discrimination? And again, add bullying in addition to discrimination and harassment. So I think we want to see if there are any questions. We've been looking at the feed. Sam, was there anything that you thought we should raise here and address at the end? I think you're on mute.
You're on mute, Tim.
Of course I am. Okay, I was gonna say it. I'm trying to pull up the questions, and because I think we do have time to answer a few. Don, I don't know if you've had luck in picking some that we can start with.
I think one question in the chat is, can we restrict political discussion via company-owned communication channels like Slack? That's a question that we get frequently. And I don't know, Sam, do you want to start on the NLRA side of that?
Yeah, so I would say the answer is yes, and you certainly can restrict political discussion, and a lot of times especially since October 7th, employers have done just that because they've had conversations at work really devolve and get out of control. I think that it's important, though, to be really clear on what is the scope of communication that you're prohibiting, because again, you don't want people to be engaged in uncivil and potentially hateful rhetoric. You want them to focus on their job, and employees have the right to talk about the terms and conditions of employment. So, and given the gray areas we talked about, that certain social issues do seem to fit under the ambit of terms and conditions of employment, you want to be careful that your policy leaves enough elasticity so you're not chilling those speech rights.
I would add that outside the US, they're going to be looking at, I think there's this presumption outside the US that it's a neutral space. So they're going to look at what content is the employer more actively censoring or punishing than others.
I see another question, which is, does mention of political groups that have views that would be Title VII give rise to a claim? Example, Trump 2024, given that Trump has stated particular views on race, national origin, ethnicity, sexual orientation, does that equal a violation? So I would say, whenever we get one of these counseling questions, the very first question is exactly what did the employees say? Because it's so fact specific and it's going to depend a lot on the exact language used. But I think just a simple statement of Trump or Biden 2024 without more, even though, of course, we can all sort of infer lots of things from that statement on all kinds of issues, including protected classes, that itself would not equal a violation. Anything to add on that, Sam? Or
yeah, I would just add that I think if anyone has a few minutes of free time, I really recommend reading the First Circuit decision relating to Whole Foods and Black Lives Matter statements by employees, because they do a really good job of laying out when conduct violates Title VII, because you're actually targeting employees because of who they are or who they associate with versus treating everyone the same regardless of background for making the same types of statements. So to Don's point, as long as you're treating a Trump 24 and a Biden 2024 sticker the same, you're really insulated from a claim by, let's say, a white nationalist that they're being targeted, because you're treating any supporter of any political candidate exactly the same.
Okay, could we go to the next slide? I just want to, while we wrap up here, just want to sort of highlight how our Cultural Flashpoints team can help on political expression as we all hurtle toward an election season. So we are available to help with trainings or policies. We've talked a lot about making sure that your policies are up to date. And this is a great time to do that. We also just do a lot of counseling in this space when you get a sticky issue and want help thinking through all of the legal implications and practical options, or maybe do some benchmarking with how other employers are handling similar issues. We are available for that. And then next slide. We're also seeing these issues really increasingly boil over into litigation. So I know the EEOC General Counsel has indicated that they are seeing an uptick in charges related to October 7th and the Hamas-Israel war, and charges of anti-Semitism and Islamophobia. And in some cases, they've gone beyond charges and are actually in federal or state court. And also conducting investigations. As we mentioned, a lot of times investigations are in order in these kinds of situations, and that's something that we can assist with as well. Next slide, please. And so we're at the hour. I wish we could get to everyone's questions, but unfortunately we are out of time. Here is our contact information. Any of us would welcome questions after the webinar. I know lots and lots of interesting issues happening in all of your workplaces right now, and just want to let you know that we are here to help. Thank you so much for being here with us today.